You're watching EstatePlansPlus.com.
If you are a parent or grandparent and you want to provide an inheritance to a child or grandchild, you want to make sure that the money will end up helping the person and not disqualifying them from disability and health care programs. There are two ways that people approach this need for planning: informally, with unwritten understandings, or more formally, with a written plan. First, people who don't have a definite plan may rely instead on surviving children or other family members to figure things out in the future, and then informally distribute an inheritance to the disabled person. There is nothing better than loving family members who are willing to take time and care and understand. But families in this first group who rely on informal planning risk misunderstandings that can happen when unwritten goals leave uncertainty about details and decisions. This uncertainty about financial and eligibility details can take time away from the primary purpose, caring for the person. People in this informal planning group may later realize the value of written plans that track the needs of the disabled person and supplement disability income and benefits programs that the person is eligible to receive. The second alternative is to provide a written plan, a plan that makes it possible for your surviving family members to understand and honor your intentions, and that instructs them on the steps they need to take to protect the interests of the disabled person. Which group are you in? If you're a parent or grandparent in Group 2, the structure of your written plan will include a supplemental needs trust that complies with public benefits and tax laws. We protect public benefits eligibility with the supplemental needs trust. The trust serves to enhance quality of life for the disabled person by purposeful funding of supplemental needs. You can download a PDF list of Supplemental Needs Trust purposes anytime from my website. These are purposes that don't conflict with or disrupt the housing and food needs that are paid by Supplemental Security Income and Section 8. If your beneficiary doesn't rely on SSI or Section 8, your trustee isn't limited to this list and can use the trust funds for anything the trustee decides. Looking beyond public benefits eligibility, a written supplemental needs trust also gives you the same asset protection features that are built into other types of trusts. The trustee of a supplemental needs trust has discretion over whether to distribute anything from the trust fund. The trustee's discretion, combined with spendthrift laws, will prevent creditors from reaching any of the funds. Spendthrift protection of a trust is important when an inheritance is left for a person who could become subject to divorce, lawsuits, debts, and health care costs. A written trust instrument protects assets from other factors, like the disabled person's immaturity, their lack of fiscal responsibility, and from vulnerability to financial predators at any age, including and especially in later years, when scammers and predators are most actively targeting vulnerable people. In an educational meeting, you can learn how your family is specifically served by a supplemental needs trust. In the next video, the big difference between a third-party supplemental needs trust and a first-party supplemental needs trust.